questions? Well, I think we'll get started. I want to welcome you to Washington Legal Foundation's annual media briefing on the Supreme Court at midterm. My name is Glenn Lambie. I'm Chief Counsel of the Foundation's Legal Studies Division. This program has traditionally attracted precipitation, usually in this form of snow. So this is the first time in a bunch of years where we've had back-to-back programs at this time of the year. We've had to cancel several over the last 10 years or so because of snow. We got plenty of rain today, so those of you who decided to stay in your offices or at home and watch us, welcome. And those of you who had planned on watching online as well, welcome as well. I'm going to introduce our moderator, Jay Stevens, who's the chairman of our Legal Policy Advisory Board. I did want to note first that all of the briefs, press releases, et cetera, that we've done in the cases that are going to be discussed today, that Jay's going to mention, we filed in or on our website. Please take some time to check those out. We still have a couple of briefs to file coming up this term, but we're definitely anxiously awaiting the arguments and the ones coming up that we file briefs in. Jay is, in addition to being the chairman of our advisory board, is counsel to Kirkland & Ellis here in DC. He served for nearly 13 years as senior vice president, general counsel, corporate secretary at Raytheon Company. He also had a distinguished career in public service as associate attorney general of the United States, U.S. Attorney for the District of Columbia, Deputy Counsel to the President of the United States, and he also served as Deputy General Counsel of Honeywell before he started his public career. Jay, if you could get us started.
Thank you very much, Glenn. Delighted you can all join us today, and particularly delighted that we have such a distinguished panel to share some thoughts and ideas and insights regarding the term at the Supreme Court. I'll just note at the outset that Glenn leads a very active and effective litigation effort here at Washington Legal Foundation. For the 2019 term of the Supreme Court, we've filed briefs in 17 cases. Some of those are cert briefs, some are merits briefs, and some have been rejected, but a number of them have been taken by the court and have been argued before the court, and some are still pending at this time. But we're quite pleased and proud of the work of the Washington Legal Foundation staff. They do a tremendous job, and the foundation weighs in on a number of important issues to economic liberty and free enterprise. Today we are, as I said, joined by three very distinguished practitioners before the courts. I will introduce them in the order in which they're going to make some comments to you regarding cases that are of interest to them, to us, and hopefully to you as well. First is Elaine Goldenberg. Elaine is a partner at Munger, Tolles, Olson. She's here in the Washington office of Munger, Tolles. She joined the firm a couple of years ago, 2007. Prior to that, she had been at the United States Department of Justice as as an assistant to the Solicitor General. She has argued a dozen cases before the Supreme Court, and during her tenure at the SG's office, she briefed more than 20 cases on the merit stage that went to the court, and more than 100 cases at the cert stage. So a depth of experience both at the briefing stage and at the argument stage. Prior to joining the Justice Department, she was in private practice, and she's clerked previously, initially for Judge Rakoff in the District Court, Southern District of New York, and then for Judge Sandra Lynch on the U.S. Court of Appeals for the First Circuit. Following Elaine will be Sarah Harris. Sarah is a partner with Williams & Conley here in Washington. She has represented clients in a range of high-stake appeals at the Supreme Court, at federal and state appellate courts across the country as well. She's argued cases in the federal courts of appeal and in state Supreme Courts. Her cases have covered a wide range of issues: commercial litigation, constitutional law, administrative law, civil procedure, antitrust, false claims, etc., products liability. She also clerked for Judge Sandra Lynch on the First Circuit, and she clerked for Judge Larry Silberman here on the DC Circuit. Andrew Pincus will follow Sarah. Andrew is a partner in the Washington, D.C. office of Mayor Brown. He has argued, I think, in excess of 30 cases in the Supreme Court, including 2 cases this past term, and is co-founder of the Yale Law School Supreme Court Advocacy Clinic. His experience in public service includes both as an assistant to the Solicitor General, as General Counsel of the Department of Commerce, and as law clerk to the Honorable Harold Green, the United States District Court here in the District of Columbia. So with that, I'll turn it over to Elaine, and after each of the panelists has done an explanation review and some comments on cases that are of focus and interest to them and to us, we'll have a series of questions. We will invite questions both from the audience and certainly from all of you online. Please be comfortable and raise questions. We will have some questions here from the panel as well, and encouraging the panelists to comment on each other's comments. So, Elaine, the floor is yours.
Great, thank you. Thanks very much for having me today. It's a pleasure to get to talk to you all. I'm going to cover 3 cases, one relating to SEC disgorgement, a trademark case, and a copyright case. So I'm going to start by talking about the SEC disgorgement case, which is Liu versus SEC. And there's a statutory provision that allows the SEC in court to obtain any equitable relief that may be appropriate or necessary for the benefit of investors. And the question in this case is disgorgement such relief? The SEC definitely can get disgorgement by statute in its own administrative proceedings. It can get civil penalties and injunctions in court, but the question is, can it get disgorgement from courts? And this question is really significant, at least in the sense that the SEC obtains billions of dollars in disgorgement through awards from courts, and every year, just huge amounts of money in disgorgement. And it's also significant because although not all the statutes are worded identically, there are also other federal agencies that, under similar sorts of statutes that give authority for equitable relief or injunctions, are also out there obtaining billions of dollars in disgorgement. And the question is that authorized? And this case in many ways arises from a case that I actually argued in the Supreme Court a few years ago called Kokesh. That was a case about whether SEC disgorgement remedies are penalties within the meaning of a statute of limitations provision. And I thought a couple of things flowed from that case. One is that the justices at the argument expressed a lot of uncertainty about exactly where the authority for disgorgement was coming from. And I think that gave rise to a lot of litigation, including this case, Liu. And also, the court's decision that disgorgement was a penalty really did sharply raise this question of, well, is it equitable relief then? Because in the days of the divided bench, courts of equity were not supposed to be engaging in anything that looked like a penalty. So this case brings those questions to the fore, and it's an interesting case. In a lot of ways, there are sort of technical statutory interpretation questions going on here, as both sides try to deploy various statutes that either expressly give authorization for disgorgement to other people besides the SEC, or seem to contemplate that maybe the SEC will get disgorgement remedies in court, but without expressly authorizing it per se. And then there's also a sort of policy debate about how important is this really. Could the SEC resort to other kinds of remedies if it can't get disgorgement, or will it really be something that will impair the agency's ability to enforce the security laws if disgorgement can't be captured? And if I could venture a prediction in this case, it seems to me that partially because of the Kokesh decision that I described earlier, partially because the court took up this case without any circuit split, seemed eager to revisit the issue, and partially because of a sort of larger thing that's happening at the court, I think, in terms of how agencies are viewed. It seems to me like the court is going to be pretty skeptical of this particular form of agency power and view it as a sort of arrogation of power that Congress didn't confer on the agencies. And if Liu does win and the SEC loses, there are some questions, I think, as I mentioned before, about the practical consequences. Will the SEC try to operate more in its own administrative process, and where it definitely can get disgorgement, but where it faces some other challenges? Will the SEC try to seek greater civil penalties in the courts than it has? Will Congress step in and act and give the SEC this express disgorgement authority that it currently lacks? And then There are also some cases pending, I'll just mention briefly, cert petitions pending at least, not cases pending before the court, involving the FTC, who has a statute that authorizes the FTC to get an injunction, but which courts have long interpreted as also authorizing disgorgement until recently when the Seventh Circuit stepped away from that kind of shared consensus among the circuits and engaged in a more rigorous form of statutory interpretation, I think more along the lines of what the Supreme Court seems likely to do. The cert petition is in a case called Credit Bureau, and the Seventh Circuit's decision is in a case called Credit Bureau. One thing that's interesting about that case is that the cert petition was filed by the FTC itself under its independent litigating authority. The Solicitor General's office didn't sign that cert petition. So I assume that that may in part reflect the SG's office feeling like the Liu case, the SEC case, will shed some light on these issues, but it may also be that that office did not see its way clear to arguing that the word injunction captures disgorgement, because on their face, those two words mean different things. So it's a really interesting set of issues, and we'll have to see how it turns out. But like I say, if you ask me to predict, I think the SEC is going to need some congressional help to get disgorgement out of courts. The next case that I want to talk about is Booking.com, which is the trademark case. And that's a case that is in some ways about the internet age and also in many ways about a Supreme Court decision from the 1800s, which is a sort of interesting confluence of things. So the question in that case is whether Booking.com, which is a website that you can go to book travel, is that term is generic. So in other words, a generic name for a class of goods or services rather than indicating a brand, and therefore not entitled to trademark protection. And the United States is the party that petitioned for cert in this case. And the United States argues that booking is generic and also .com is generic, just means company essentially. So when you stick those two things together, what you have is something that is still generic, and it doesn't matter how much consumer recognition that phrase may have. It doesn't matter what surveys show about what consumers understand. None of that matters. It's all just generic. And in making that argument, the government relies really heavily on a decision from 1888 called Goodyear Rubber. And that case said that names like the Goodyear Company couldn't be trademarked because at that point, apparently, Goodyear just indicated the process for vulcanizing rubber. That's not what it means to me, but that seems to be what it meant in the late 1800s. And the court said in that case, just adding company to that didn't help because that just shows that people came together to vulcanize the rubber and rather than doing it individually on their own. And so the government analogizes to that to say adding .com is the same kind of thing. It doesn't help you get over this hurdle of having a generic term. So the other side just filed its brief against the United States yesterday. And it made I thought, a strong counter. And one of the things it said is, Goodyear Rubber reflects an outdated view of the world before the federal trademark statute was enacted in 1946 that said that fewer things were entitled basically to trademark protection than is true today. And the brief also says, look, there's a really well-accepted test that courts have applied and that, in fact, the Patent and Trademark Office has applied to decide whether something is generic or not, and that's primary significance. How do consumers understand the mark? And that includes surveys of the kind that were presented in this case. And the brief presents a welter of examples of trademarks that the PTO has granted that would fail under the government's test. So it casts doubt on .com marks, but also marks that use the equivalent of store or company after a descriptor. So the flagpole company, the mattress shop, or marks that use a phone number or location like 1-800-Lawyers. And so Booking.com's brief really just raises a specter of what it says is mass extinction of existing trademarks if the government's test is accepted. And so in the end, I think, to me anyway, what's really going on in this case, even though obviously on some level it is about what happens when you add .com or the equivalent to some other term, the real fight here seems to be over how to assess genericness in the first place. And whether you use this primary significance test or whether you just sort of know it when you see it, which seems to be more or less the government's approach. And surely that's true sometimes, but it also creates hard problems, I think, at the margins. And so it's not clear to me that the court will find it administrable or appealing, especially when the other side has done a good job to suggest that there's going to be a lot of practical difficulty and confusion that would arise from adopting the government's test, and a lot of change to take the government's approach. But obviously there'll be more briefing yet, and then also argument, and we'll have more information after we see those things. The last case I want to talk about, and I going to be hard for me to do it justice in a brief period of time because it is a very complicated case, is Google versus Oracle, which is, I think, a monumentally important copyright case about copyright protection for computer code. And I do think that it will be difficult, actually, for the court to wrap its arms around this case. They took the case, so they want to wrap their arms around it. But it is highly technical, and I find myself, and then a number of people I've spoken to, I think have also found that the thing that the case is about is actually very difficult to grasp unless you have a real background in computer coding. So I think the parties take different approaches to this. Google tries to simplify, Oracle tries to kind of lay out all the complexities, but I think it's definitely going to be a challenge for the justices and for their law clerks. So I'm going to try to very briefly explain what the case is touching on, and then just note the legal questions and the sort of bigger policy question that's swirling around this case. So there's the Java programming language, which is widely known and used by developers, and it allows use of computer programs to carry out a particular task, like if you wanted to select the larger of two integers. And Java developers know and have at their fingertips and can produce readily something that the petitioner refers to as calls. So those are sort of like names for a function. And the calls correspond to instructions that the parties call declarations. So if you change the declarations, the calls won't work. Oracle developed certain declarations by writing the code. Google reused them because it wanted the developers to be able to use the calls that they know and call up this sort of set of instructions. And the questions in the case are those declarations themselves copyrightable at all? Are they a method of operation, or are they a form of expression that's so merged into a method of operation because it's hard to express the method of operation in any other way that they're no longer copyrightable? There's also a significant fair use question in the case. There was a jury determination, actually, of fair use in this case that the Federal Circuit overturned. And so there's a question of whether the factors that go to show whether there's fair use are satisfied here, or whether the fact that this is a commercial use and a use that Oracle says was harmful to it as Google's competitor is enough to knock it out of the fair use category. And there's also a larger policy issue here, which I think is caught up to some degree in the fair use analysis, which is that what Google is saying is, look, the accepted understanding in the software industry is that we could do this, and you don't have to go through the inefficiencies of rewriting these functional things every time. And if you did that, and you made developers learn this new lingo every single time that someone developed a new platform, then innovation would be stifled. And the things that have made the technology industry grow would be hampered, and software wouldn't be interoperable, and that would be a big problem. And Google has a really impressive array of amicus support from all sides, from Microsoft, from EFF, which you wouldn't normally see on the same side as Microsoft in a case. And Oracle obviously takes a different view of the case and says, look, this is just straight up copying. Google could have, with a lot of effort, admittedly, written this itself, come up with different calls and different instructions, and it didn't do it for its own convenience. And the amicus briefs for Oracle aren't in yet. Oracle just filed its brief yesterday. But presumably those amicus briefs are going to include the United States, which has also filed a couple of cert stage invitation briefs in this case. So I think it's a little hard to know what's going to happen here. I mean, I assume in taking this case, the court was moved by a sort of, calling it consensus is probably too strong, but a lot of people saying that a ruling for Oracle does real damage in the world. And given the difficulties that I think the court will confront in understanding what's happening with respect to the computer code in this case, how it works, how it was used, it could be that those practical considerations are going to end up driving the result. On the other hand, the court sometimes defaults to the United States in highly technical and complex cases and uses the United States brief and the United States argument as a guide. And so that also could happen here. I find this one a little harder to make a firm prediction in, but there's no question that it is truly important to this industry, and I think also to other people who have concerns about copyright. I think there are copyright holders in other industries who want strong copyright protection, who don't want to see a broad interpretation of the fair use doctrine and the like. So this is, I think, one of the very most important business cases of this term.
Thank you, Elaine. Sarah?
Hi everyone, thanks so much for having me. It's a real delight to talk to you. My trio of cases, I think at first glance, are cases that you would think only law nerds who are really into arcane jargony issues would love. But I hope to convince you that these are cases that everyone, including non-lawyers, should actually really care about, because each one gets to some pretty fundamental and age-old questions about the Constitution, and that's always fun. So the first one up is SELA Law versus the Consumer Financial Protection Bureau. Argument in that case will be on March 3rd, and I think it's fair to say it's one of the most hotly anticipated and important cases of the term. It's also not super accessible. So before I kind of get into what are the parties' arguments and what's the lay of the land, I thought I would kind of give a sense of what's the upshot here and why you should care. So this case really is about how much control the Constitution gives to the president to supervise the executive branch. It's one of the fundamental questions about our structure of government. And specifically, how much can Congress insulate various federal agencies from presidential control by allowing the president to remove agency heads only for cause instead of removing them at will? The agency here is a new one. The CFPB was created in 2010 to regulate lots of consumer financial products, and it has very broad powers. But make no mistake, this case could affect many, many more federal agencies. Most obviously, the Federal Housing Finance Agency, which oversees Fannie Mae and Freddie Mac, has the same sort of set of issues. And then, the ruling could potentially affect all so-called independent agencies, the agencies that have a structure where they have for-cause removal protections from multi-member bodies. So that includes the FTC, the Federal Election Commission, the FCC, the SEC, the list goes on and on. So you should care about the case because it could really profoundly affect the way that federal agencies operate and are structured going forward and how responsive they are to elected officials. So there's kind of two camps on this, and you'll probably instinctively fit yourself into one or the other. The first one is the unitary executive sort of theory of this, which can be summed up with President Truman's famous statement that the buck stops with the president as the head of the executive branch, which means the president really needs to supervise and control the entire executive branch. There is no sort of fourth branch, like a special category of, some branch of government for independent federal agencies. And that means that unelected agency heads ultimately have to be accountable to someone who's democratically elected, i.e. the president. And that really does include the power to remove, which is one of the fundamental tools of controlling people in the executive branch. If that's your view, Chief Justice Taft is probably your patron saint. He is, of course, the only person to have ever been both president and Chief Justice, and his post-presidency 1926 opus, Myers versus United States, is the sort of foundational opinion for this view of the world. And that case held that the president alone has the power to remove heads of executive branch departments, including ones who are appointed through Senate confirmation. The other kind of school of thought is a more functional approach, which is not all executive branch agencies are created equal. Some need to be accountable to the president, like, say, the State Department, but others are bodies of experts, and they need to be more independent to perform sort of technocratic functions that are more legislative or judicial in their nature. So to insulate those kinds of agencies, this theory would say Congress needs to be able to protect the agency heads from sort of the political process and the president and the rest of the executive branch by making them removable only for cause. And that's the theory of the 1935 opinion Humphrey's Executor, which is the New Deal era case upholding for-cause removal restrictions on FTC commissioners. So you may have noticed both of those cases that I cited, Myers and Humphrey's Executor, are like super old. So you may be wondering, why are we confronting all of this now? Well, the CFPB came around, as I said, in 2010, and it has an unusual structure, which is most independent agencies have multi-member, often 5, and they are selected under staggered terms. Sometimes they also are structured so that they are divided between Republicans and Democrats. But the CFPB is different. It has a single head who serves for one 5-year term, meaning that a president, in theory, might go through his or her entire term of office without any chance to appoint this person. And so the parties kind of start off from that premise. Petitioner SELA Law is challenging the CFPB structure after being subject to a CFPB enforcement action. And the petitioner joined with the government, the United States in this case, and both agree that the CFPB's structure is unconstitutional. They say multi-member bodies are different than single-head agencies because there's something special about collaborative decision-making that happens in these multi-member bodies that have staggered terms. You are forced to compromise, and that creates a kind of stability and just a sort of special sauce, I think you could say, that is very different from a single-head agency like the CFPB, where it is a single person picked by a single president, perhaps to reflect that president's views. And so that person can kind of impose his or her own view on a very, very powerful agency without the meaningful check of at-will removal. And so both the government and Sila Law sort of say that is a novelty that is unacceptable, and that Humphrey's executors' sort of endorsement of independent agencies and the multi-member bodies with for-cause removal is really the outer limit. And they make a backup argument, which is, in all events, if you think that this case is controlled by Humphrey's executor, please overrule that decision, which has not stood the test of time. It's been weakened by some ensuing decisions that we can kind of talk about in some of its premises. And then the fun twist of this case. So, as I said, the petitioner and the government actually agree that the CFPB has constitutional problems. That meant the court had to appoint an amicus to defend the CFPB's constitutionality. And Justice Kagan did the appointment, and she picked Paul Clement, which was a totally brilliant choice. And Paul's brief is really, really interesting, I think, because it is very much written, I think, for the conservatives on the court in particular, looking for a way to get to 5 votes to save the CFPB, or at least sort of sow some doubts in the court about what they're biting off if they want to say that the removal restriction is invalid. And sort of the premise of his brief is sort of, let's take a step backwards to a lot of first principles to chip away at this sort of unitary executive theory and sort of put some pressure on it. So for instance, since the founding, he says, Congress has had a lot of power over what agencies exist. It can create them, it can structure them. It can regulate who reports to whom in the agencies, and also qualifications for office. So given all of those things that Congress can do, what's the big deal about imposing for-cause removal as a restriction? It's sort of part and parcel with these other powers, the brief kind of says. And so I think that's a really interesting take on the case, and a way to kind of step backwards from a lot of the debates that happened in the decisions below. Then the other part of the case, which has been a sleeper issue but is super important, is actually the remedy, which is what happens if for-cause removal restrictions are unconstitutional. Notably, the court is clearly very interested in this. The petitioner's cert petition didn't address remedies, and the court added this expressly as a question presented. And so the question is the for-cause removal restriction severable, meaning can you just sort of take that out and keep the CFPB functioning, or does the whole CFPB fall? The petitioner's brief definitely takes a very interesting tack on this in the first instance by telling the court it doesn't have to resolve the question presented, which is definitely an interesting take. But then the sort of fallback is that the whole CFPB would fall because Congress would not have intended to have an agency that is subject to at-will removal, that was sort of a fundamental part of the bargain in creating the CFPB. And the government sort of opposes that position and says, no, Dodd-Frank has a severability position. Let's just sort of carve this out. That's what the court often does in separation of powers cases. So nothing to see here, just sort of, it can be at-will removal and we'll call it a day. So why should you care about this? The severability doctrine is not very fun. It matters a lot if you're someone bringing a challenge, and obviously there are many, many, many people who have been subject to CFPB enforcement actions, for instance, who care very deeply about whether the CFPB can sort of continue to exist, and whether its pending actions or even previous actions are not valid based on this constitutional defect, if that's where the court goes. So predictions for this, I think the going theory into this is the court took this case and the for-cause removal restrictions in trouble. This is a court that more than any other, I think in recent times, is extremely interested in separation of powers issues. Justice Kavanaugh, when he was on the DC Circuit, wrote a dissent in one of the early CFPB cases in which he said he thought the for-cause removal restriction was unconstitutional, but he thought that it was severable. And, many of the members of the court right now have extensive executive branch experience that I think has lent itself to a very, very serious look at separation of powers issues. The other fun thing about the case is battle of Scalia clerks. So you have Noel Francisco, the Solicitor General, Kenan Shanoyam arguing for the petitioner, and Paul Clement arguing for the appointed amicus. All three of them are Scalia clerks, and that's probably no accident, because if you want to talk about a justice who had the most profound, I think, importance for a lot of separation of powers thinking in this case, it's obviously Justice Scalia and his dissent in Morrison v. Olson. So this should be a really fun one. A lot of enthusiasm for that. My next case is Barr versus the American Association of Political Consultants. So I'll read the question presented, which is whether the government debt exception to the Telephone Consumer Protection Act's automated call restriction violates the First Amendment, and whether the proper remedy for any constitutional violation is to sever the exception from the remainder of the statute. So, yuck, right? Like, that does not sound like a case that people would care about. But I still think you really should, for two reasons. First of all, this is really a case about how you can tell if a speech restriction regulates on the basis of its content. The Supreme Court has taken an increasingly pro-speech line in its First Amendment cases, most recently in Reed v. Town of Gilbert is sort of a seminal case in this area from 2015. And that case, I think if you take it literally, sweeps very, very broadly and says speech based on content is subject to strict scrutiny, likely to go down, and speech based on content includes a lot of stuff, like literally anything that requires you to look at the content of the speech to evaluate its constitutionality. And so the question has been sort of, does Reed really mean what it says? How broadly does it sweep? And so this case has sort of teed that issue up because the TCPA says there's a general rule, you can't engage in automated calls, so no speech there, but then they have various exceptions. And the one here is for government debt collections. It says, well, you can do automated calls if you're doing it solely to collect a debt owed or to or guaranteed by the United States. So most federal student loans would fall in that category. And the question is really, does that carve out make the automated call restrictions content-based? The government says, no, laws based on purpose are not really content-based, they're kind of based on their intent and motive. And if you look at the specific speech, you could say the same thing if you want to collect government debt versus private debt. And the petitioner says, no, that's crazy. Reed itself says a statute can be content-based when it defines regulated speech by its purpose. You have to actually look at the content of this call to figure out if it's prohibited or not, and content and purpose are inextricably linked. So I think that's important. It is going to be one of the most important sort of post-Reed cases in kind of figuring this hard area of law out. And the second question kind of ties back to what we were talking about on SELA, which is, if it's unconstitutional, then what? Do you sever the exception? Well, that doesn't make a lot of sense because the exception actually restricts less speech. Or do you strike down the entire TCPA automated call provision? So that's going to be an interesting one, both on the constitutional question, which is, I think, pretty hard, and also on the remedies question. So my final case is Gudez versus the Bureau of Alcohol, Tobacco, Firearms, and Explosives. It's a pending petition. It's being relisted multiple times. And it's a really fun case for administrative law issues. So it arose from the administration's rule classifying bump stocks as machine guns. And the upshot of that is that possessing a bump stock is a felony that subjects you to criminal prosecution. The petition sidesteps the question of whether that interpretation of the definition of a machine gun is correct or not. It instead sort of says, this case, it's really an interesting litigation sequence. So the government got challenged on the rule. DOJ has always said, we don't want Chevron deference. Please, do not give us Chevron deference. We want to win or lose based on whether courts agree that our interpretation of a machine gun is right. The DC Circuit says, we don't care. They say, you know what? We're not sure you DOJ have their best reading of the statute. It's certainly reasonable, though. Statute's ambiguous. So even though you disclaimed it, you're getting Chevron deference anyway. Even though the government kept swearing up and down, please don't give me Chevron deference. And the court says, well, you can't waive Chevron deference, so you're getting it anyway. And in doing so, the DC Circuit said, Chevron, the idea that you defer to, when there's an ambiguous statute, you defer to the agency's interpretation of the statute, trumps something called the rule of lenity, which is the rule that if there's a criminal statute that's ambiguous or unclear, the tie goes to the person subject to criminal prosecution, not to the government. So that's kind of an interesting clash of interpretive principles, and several justices have expressed deep concern with the idea that the tie should go to the government when there is a criminal statute involved, and sort of there's a theory that the rule of lenity really needs to be the principle that trumps, because that is sort of the more liberty-preserving principle, especially when you're talking about being prosecuted for a felony. So that's the kind of fight in the case. The weird thing about the case, of course, is still the government continues to maintain, please don't give us Chevron deference. So while the petitioner and the government agree, and I think are very skeptical of the idea that Chevron deference should apply, let alone to trump the rule of lenity, the government does not want the court to take the case because they're sort of saying, okay, well, we can have a debate about rules of construction and how to think about statutes, but why bother? Because in this case, the government says, we're just right about the statute, so there's nothing to see here. I think it's probably more likely to prompt separate writings than a grant, if I had to guess, but it is an extremely interesting and important issue of administrative law.
Thank you, Sarah. Andy?
Thanks, Jay, and thanks to the Washington Legal Foundation for asking me to be here today. Before turning to some additional cases, I can't resist saying a word about the CFPB case, because I've been involved in that case representing the Chamber of Commerce and in a bunch of other cases raising the same issue about the CFPB. And I think Sarah gave a terrific presentation. The one thing that I find very interesting about the defenders of the CFPB's structure is they actually believe that the sort of total insulation of the CFPB from accountability to either Congress or the president, because in addition to the restriction on removal, the statute exempts the CFPB from the appropriation process. They get a basically $650 million check from the Fed every year to spend as the director wants in his or her sole capacity. So no control by the political branches through the appropriation process. And the people who defend the structure say it's really important to insulate this important agency which has all this regulatory power from the political process, because otherwise political concerns will actually infect what it does. And I think the framers would be a little shocked to hear that a nation that was founded on control by the people actually adopted a structure that permits the total insulation of an agency with very broad power. This is not an agency that just regulates banks. This is an agency that regulates any entity that engages in any of a number of 10 or 12 financial activities, which basically every big company in America does, from any accountability to the political branches. So it's a very interesting argument that's being made on the other side, I think, if you step back and look at it in the context of what the framers probably thought they were setting up. The other interesting thing, I think, is about severability. You know, severability isn't such a big issue if you have a Congress and executive branch that can actually pass legislation, because then in reaction to whatever the court does, you know, there would be a backup to in the legislative process to repair, address the fact that part of the statute was struck down as unconstitutional and replace something. But our current politics doesn't really allow that. So in many of these cases where severability is at issue, the court may have the very last word, or at least will give a significant advantage to one side or the other, depending on what it decides. So the option here, there are sort of three choices, as Sarah said. You sever you say that the for-cause removal restriction is unconstitutional. The agency sort of marches along, doing everything that it does, with a director that's responsible to the president. In that situation, you have probably the invalidity of a lot of past actions of the agency that are still subject to challenge in court, but you also have a director that, for example, when a reg is challenged, can decide to repromulgate it on an interim final basis in order to provide some stability in the system. If you go the other two routes, which is actually all of Title X of Dodd-Frank, which establishes the agency is not severable and therefore has to be eliminated, then for entities that operate in this space, you have an interesting problem, because the CFPB has issued a lot of regulations. Companies have have expended lots of money, tens of millions, if not hundreds of millions of dollars, putting in compliance systems. But those regulations are gone, and there's a question about whether those compliance systems comply with the statute that it's the state of the law before Dodd-Frank was enacted. So it's an interesting question for the corporate community, which has definitely not been a fan of the CFPB. And then the don't decide option is, in a way, the worst of all possible worlds, because then if you're a regulated entity, you don't really know, is the CFPB still working? Is it not working? Has the power gone back to other agencies? Hasn't it? So it's really going to be a very interesting question, I think, to see how the various players line up in considering what they want on severability, which, as Sarah mentioned, is an issue in the robocall case. It's an issue in the Puerto Rico bankruptcy case. It's an issue in the Affordable Care Act cases that are pending on petitions before the court. So severability is a hot topic, although it probably is the legal nerdiest of legal nerdy issues. But with that, let me turn to a pair of cases, petitions brought by Ford Motor Company that were granted, Ford v. Vandermeer, and then a second case, a Ford case that arises out of Montana, that take any lawyers who are listening back to first-year civil procedure. You probably remember jurisdiction, and in particular personal jurisdiction. Courts have to have jurisdiction over the defendant in order to adjudicate the case, and that comes in two flavors: general jurisdiction, which means the court can adjudicate any claim, and specific jurisdiction, which means that the court can only adjudicate a claim if it has a relationship between the forum, the defendant, and the plaintiff's claim, and whether that relationship is sufficient to give the court jurisdiction. Before a case called Daimler that was decided, I guess, 5 or 6 years ago, most courts in the United States applied the rule that if a company had a substantial presence in the forum, it was subject to general jurisdiction. So most cases were adjudicated on a general jurisdiction basis. Daimler was a sea change in an opinion written by Justice Ginsburg for 8 members of the court. The court said, well, that's wrong. General jurisdiction is only available in the corporation's place of incorporation or place of principal place of business, except for a very small exception, which almost never applies. And otherwise, you need specific jurisdiction. And the court reaffirmed that rule in a pair of cases decided subsequently, one involving BNSF and one involving Bristol-Myers Squibb. So the result is, if you're a plaintiff, very difficult to rely on general jurisdiction these days. What is specific jurisdiction? And so an issue that really was relegated to the sidelines when general jurisdiction was all the rage has now really come to the fore, which is the court has said that the contacts with the forum that are relevant for general jurisdiction have to be intentional contacts with the forum by the defendant, and that there has to be some relationship between those contacts and the plaintiff's claim. The plaintiff's claim has to arise out of or relate to the defendant's contacts with the forum. What does that mean? Lower courts are all over the map about whether that means that there has to be some causal relationship between those contacts and the plaintiff's claim. Some courts say no causal relationship at all. Basically, as long as the defendant's doing something in the forum, that's good enough. Probably the most extreme example of this is some lower courts that have said, in a context of drug product liability actions, if the drug company in conducting a trial had some participants in the trial in the state in which the claim is brought, and it's brought about that drug, that's good enough, because the trial led to the drug approval, which led to the manufacture and sale of the drug, which led to the sale of the drug to the plaintiff, which led to the plaintiff's claim. Pretty attenuated and not very causal. Some courts have said, well, there has to be at least some causal link in the chain. Maybe it doesn't have to be proximate cause, maybe it doesn't have to be but-for cause, but those contacts with the forum have to have some causal relationship to the plaintiff's claim. And the case that's been granted is going to, I think, shed some light on that finally. These are 2 car product liability cases. Vandermeer is a case that arises in Minnesota. A Minnesota resident was the plaintiff. The accident occurred in Minnesota, but the Ford car involved was not designed, manufactured, or sold in Minnesota. In fact, it wasn't registered in Minnesota until 17 years after it was sold, so a long time after. Ford's argument is nothing that we did in Minnesota has anything to do with this plaintiff's claim. The plaintiff says, well, maybe that's true about this car, but you sold at the same time lots of other cars to other people in Minnesota. Why isn't that enough to give the Minnesota courts jurisdiction? And so it squarely raises this question of causation, because there's obviously no causal link between what Ford did in Minnesota and this plaintiff's claim. Why is this important? Forum shopping is a plague in the American judicial system, as most people know, and so the question, personal jurisdiction, is really a constitutional limit on forum shopping. That has a lot to do with fairness to defendants, but it also has a lot to do with federalism. And that federalism is a relatively new ingredient in the analysis that was added in opinion that Justice Alito wrote for the court a couple of years ago in Bristol-Myers Squibb, where he said, yes, one of the things that personal jurisdiction does is provide fairness to the defendant, but another thing that it does is ensure that a state with very little interest in adjudicating a dispute can't Bigfoot states that have a much more significant interest in adjudicating the dispute. And so I think one of the things you're going to see in the arguments in the Ford cases is an emphasis on federalism, and whether here, Montana and Minnesota, which are the two cases involved, really have an interest in adjudicating this dispute compared to the states where the car was initially designed, produced, sold. Obviously, potentially a very big impact on how litigation works in America. Lots of concern by the plaintiff's bar about the fact that if the Ford were to win, the negligence claim against the other driver could be brought in Minnesota, but the product liability claim would have to be brought in Detroit, probably in Michigan. But of course, that's just a consequence of the rules that the Constitution lays out. So I think a very important and interesting case to watch. One question will be, I think, what kind of tests do defendants propound? I think the knee-jerk reaction of some is to say, well, proximate cause is the tightest kind of causal restriction. We'd like specific jurisdiction to depend on proximate cause, but there's a be careful what you wish for element to that, because that means if you make a motion to dismiss on specific jurisdiction grounds, there's discovery available, and if proximate cause is the test, that discovery is going to be into all of the facts and circumstances that are highly relevant to the underlying product liability claim, and that means a really expensive discovery at the outset of the lawsuit, and also plaintiff's lawyers getting essentially all of the facts relevant to the merits in connection with that claim. So, I mean, to the chamber at least, we've taken the position that proximate cause is not the right test, and that although causation is required, it's a lesser amount of, it's just some causal link, and that the other control is provided by this federalism check on which states might be able to adjudicate the claim. So a very interesting case to watch. The second set of cases I want to talk to are pending on cert, supported by a wonderful amicus brief submitted by the Washington Legal Foundation, and they involve a statute that folks who are listening in the corporate community know well, the Alien Tort Statute. Enacted in 1789, it provides jurisdiction in U.S. courts for foreign nationals bringing an international law tort, and it lay dormant for years and years and years until it was rediscovered in a case called Filartiga by the Second Circuit, and blew up into a cause of action that eventually spawned more than 150 cases against companies on the theory that if you did business with entities, either governments that were engaged in human rights violations, or in markets where there were human rights violations or alleged human rights violations, that you were then aiding and abetting those violations, and you were subject, in most cases, to a class action in U.S. courts by the foreign individuals who alleged that they were injured by those international violations committed by the primary violators in foreign lands. The Supreme Court, in a case called Sosa, had a chance to shut down this cause of action. Justice Souter wrote an opinion for the court saying, we're not going to shut it down, we're going to leave the door ajar just a little bit, focusing on human rights violations that were like the ones that Congress was concerned about in 1789, piracy, offenses against diplomats and the like. Justice Scalia wrote a separate opinion predicting very accurately that leaving the door ajar was going to lead to a flood of these lawsuits and lots of litigation in the lower courts that they found very difficult to resolve, and that's what's happened. This case, which involves cert petitions brought by Cargill and Nestle, and full disclosure, I represent Cargill, involves a claim that by purchasing cocoa in Cote d'Ivoire and not stamping out child labor practices there, Cargill and Nestle were aiding and abetting forced labor by children in Cote d'Ivoire. The case was filed 15 years ago. It's still at the motion to dismiss stage. It's been dismissed twice by the district court. Those dismissals were reversed twice by panels of the Ninth Circuit. In each case, very large groups of dissents from the denial of rehearing en banc, 9 judges in the first appeal, 8 in the second, a total of 13 judges dissenting from the denial of rehearing en banc, but not enough to get rehearing in the Ninth Circuit. And so we're back before the Supreme Court with 2 issues. The Supreme Court a few years ago in a case called Kiabel said the presumption against extraterritoriality applies to the ATS. So there's no claim that would be extraterritorial. Our argument is, this is the archetypal extraterritorial claim. This is about things that happened in Cote d'Ivoire. The alleged aiding and abetting is the purchasing of the cocoa and the providing of farming and labor advice, actually labor advice about good labor practices in Cote d'Ivoire. And the only U.S. conduct alleged is headquarters oversight of those foreign operations. And if that's enough to render a claim extraterritorial, that means any entity that oversees foreign operations from the United States and has business in a developing country is going to be subject to an ATS suit. That can't possibly be what the court had in mind. The second question is, are U.S. corporations liable at all? International law doesn't really impose liability on corporate entities. The court 2 years ago in a case called Jesner said there is no ATS liability for foreign companies. It reserved the question about domestic U.S. companies, but the rationale that it applied there, that there was no international law norm of corporate liability, that Congress in analogous causes of action that it's created has exempted corporations, all weigh against a court recognizing corporate liability. And that's really the point of the problem with the ATS. It's courts making up liability rules. Congress, in the Torture Victims Protection Act, for example, said here's an international law norm we want to enforce. Here's a very tailored cause of action that we're willing to create. But leaving that to courts with very little, essentially no guidance, has proven to be a big mistake and has ended up with lots of companies being subject to endless liability. So we'll see what the court does. Right now, the court's asked for the SG's views. That brief will probably be filed sometime in May. Hopefully the government will say grant, and then we'll find out what happens. Thanks.
Thank you, Andy. Those of you who are here or are online, if you have a question, kindly raise your question. We'd be delighted to have the panel address it. Do we have any online at this moment?
Not at the moment, no.
Okay. Well, then I have a couple questions for the panel. Each of you should feel comfortable commenting or addressing it, but let's just start with sort of what's going on this term at the court, sort of the pace of decisions, the number of decisions, the number of cases this court seems to take. What's your sense about that, and how does it compare with prior years? Sarah, you want to start?
Sure. So this term is like truly a blockbuster term in terms of the number of very high profile and important cases. There are so many important cases that I sort of reflect on like exactly how many there are, and like you can easily forget one of the major cases because there are so many in each sitting. And I think that's caused a challenge for the court, which is those cases tend to be 5-4, they tend to have a lot of separate writings, they tend to take a while, and I think that's reflected in the pace of opinions this term, which has been unusually slow. I think at this count, there's about 3 opinions authored by individual justices, 2 per curiams. That's really small. And the number of pages in those opinions is also very low. Like these are the low-hanging fruit, like the lowest of low-hanging fruit. In terms of some of them are like one of the opinions is 6 pages long, and I don't think the other ones are much.
But it's a really important one.
The discovery rule is indeed very important. No, they're interesting cases, but this is unusual. And so I think it does reflect, there's a lot of things going on among the justices, I think, in terms of these high-profile cases. It also can't help that the chief has obviously been very busy with his dual-hatted role during impeachment proceedings, has been working, it appears, like at least 18 hours, possibly more per day for preparations for that and actually doing it. So it is a weird term in that sense. The other weird thing is there's a lot of cases that have been up at conference that have been held or relisted or that just kind of haven't been resolved in the cert process. So it's just weird.
And there's some thought that last term was a sort of quieter term with fewer blockbuster cases. And some people, I think, had the view that that was purposeful on the court's part, that there was some slow walking of some things that would have been highly controversial going on, particularly the Title VII cases, which had been hanging out there for a long time before they ultimately got granted, and that might have been the court's way of sort of easing in its new members and making sure that nothing too dramatic was going on, especially during Justice Kavanaugh's first term on the court. But it did lead to some, I mean, this isn't fully explanatory, I don't think, but it led to some kind of pent-up demand, as it were, and made this term even more full of really significant cases than it otherwise would have been.
Are you seeing fewer business-related cases coming to the court?
I don't know how it compares to prior years.
I think there probably are fewer business cases. If you look at where there are a very large number of immigration cases, not surprisingly, given the administration's focus on immigration-related issues, but there probably are 5 or 6 very, very significant immigration cases, including the DACA, the case about the rescission of the program protecting Dreamers. So I think to some extent those have crowded out business cases. There are some business cases, but I think if you look at the high-profile cases, you know, Second Amendment, abortion, religion, the CFPB case, the Title VII cases about LGBT people, that's a lot.
Mm-hmm.
There's some interesting criminal cases too, I think. Not as many as
Yeah.
the long list of immigration cases, but maybe, more than usual as well on that front as well.
Any thoughts on where the court is going or how the court sees stare decisis issues and how that can impact perhaps cases that are at the court this term? Or maybe there are none, but there may well be some.
Well, this is a court that's clearly much more willing to consider overruling precedent. A number of the justices have said so expressly in the context of constitutional issues, and so I think that sort of for litigants and lawyers, that changes the calculus, because anything that you can't really say that anything is settled, that may be opportunities if people are coming to the court seeking to change the existing rules. But as Sarah said, with respect to the CFPB case, I mean, in the lower courts, people were pretty comfortable arguing that the challenges to the CFPB, that Humphrey's executor really didn't fit this model. And the dissenters in the DC Circuit were pretty comfortable saying that that was so. But in the Supreme Court, a large chunk of the petitioner's brief is urging that Humphrey's executor be overruled. I think in a court that was less open to overruling precedent, that argument would probably be perceived as a bit extraordinary.
Yeah, I think you could say last term was really the stare decisis term. I mean, there were 4 major cases that asked the court to overrule a pretty significant precedents. And the court, took the invitation in some and not in others, and it produced a lot of very interesting writings about what is the court's sort of stare decisis role. Justice Thomas wrote separately in a case called United States versus Gamble, sort of taking the view, put very simply, if it's wrong, it's wrong. And then you see a lot of the back and forth in cases like Kaiser v. Wilkie about, what does it take to overrule a doctrine that seems questionable, but maybe isn't 100% questionable. So I think the court, having struggled with that so much last term, it's still on its mind this term. There are a number of cases that tee up a lot of more stare decisis questions. So for instance, there was one about whether you need to have whether non-unanimous juries are constitutionally permissible, for instance. And so stare decisis was one of the focal points of the argument in that case. And then, as Andy mentioned, of course, with Humphrey's executor, that's sort of another one. So I think it's just going to be more of the same. I mean, the court is taking a lot of cases that really expressly present questions about, should they overrule precedents, even like pretty old precedents, because those precedents are based on reasoning that a majority of the court is probably uncomfortable with. And is that enough?
There's at least one case this term that presents a question of whether the court should overrule one of its very recent precedents, which is June Medical, the case about abortion restrictions, where the restrictions at issue are very, very similar to, there's a debate about exactly how similar, but very similar to restrictions that the court considered 2-3 years ago, I don't remember exactly when it was, in Whole Women's Health. And so that would be a very stark, if that's the way that the court ends up going, a very stark change just within the course of a few years with a somewhat different membership on the court, but a change in course.
What about the issue of injunctions and sort of national-based injunctions by a district court somewhere, someplace? Justice Thomas, I guess, has spoken out about that in some respects. What do you, are there cases before the court now or likely to be before the court this term where that issue might be addressed more explicitly?
There are cases before the court raising the issue. The court always has a problem getting to this issue. Probably the one entity in the world that has been consistent about this issue is the Department of Justice, which has always opposed nationwide injunctions and has sought review of the question of whether they're permissible several times in different administrations. The problem for the court reaching it is once the Supreme Court decides what the underlying legal rule is, it applies nationwide. So it's a little hard for the court to then say, oh, and we're going to go on and address this question of nationwide injunction, even though we don't have to address it because we've decided what the law is, and so everybody has to comply with it anyway. So you could see, though, given the sort of controversy, that the court may feel that it has to, in one of these cases, give some guidance to the lower courts. What's interesting is, although it's sometimes perceived as a sort of, obviously there are no nationwide injunctions, Judge John Bates, who's a pretty well-respected judge in the D.C. District Court, addressed this issue in the context of an APA challenge in one of the DACA cases and said, this isn't about nationwide injunctions. The APA gives a court in an APA action this power to set aside administrative action, and doesn't that mean if it's set aside that it's set aside? Because that's the purpose of administrative review. And there's some additional new scholarship on addressing the question of, well, maybe there weren't nationwide injunctions long ago, but there were similar kinds of writs that courts issued. So I think what's interesting is, as the issues come to the fore, it's become a little murkier than it might once have been.
Yeah, I think the other interesting thing is, because, as Andy says, it's hard for the court to kind of tee it up or at least reach it in a lot of its merits cases, I think it's been dealt with very much in the court's sort of so-called shadow docket, which is when the court gets stay applications. And so I think the court has been sort of sending some pretty strong signals that is increasingly skeptical of a lot of the nationwide injunctions, especially in the immigration context, where people rush to a district court, often to enjoin the latest rulemaking on an immigration-related issue, and the court has increasingly been not letting those injunctions sort of block various programs.
We have a couple questions.
One was to get a clarification from Andy on the fact that the personal jurisdiction cases will probably be decided this term, correct?
Yes, they've been granted and they'll be argued and decided this term.
The second question involved the chief's latest brush with the most, the greatest deliberative body on the planet, and how that and other things going on sort of in the background might play into the question of severability and the how much of an impact certain justices' experiences with Congress have on that.
Well, I'm happy to go. I mean, I think there is the reality, as I said, that this is not a situation that one had 30 or 40 years ago, where Congress would react to court decisions in pretty short order. Not much happens, and anything that happens takes a long time. But I think to some extent, the severability doctrine, as it's traditionally exists, and the court has said in a lot of opinions that if a provision is unconstitutional, if there's a severability clause in the law, as there is in the CFPB statute, that weighs heavily in favor of just severing the unconstitutional provision, and as long as the rest of the statute can function, leaving it in place. There are lots of decisions that do that. Justice Thomas in a case involving gambling, of all things, basically questioned whether that view still makes sense. And I think that what we're seeing is one of the major questions is whether there'll be some reconsideration of that legal doctrine. I think you'd think that to the extent anyone's looking beyond the law books to Congress, they would recognize that to the extent they're going to invalidate a lot more, that may create problems in terms of the government being able to function, but I think they're going to probably focus mostly on the legal doctrine.
Yeah, there may be other sort of jurisprudential commitments that people have to judicial minimalism, things like that, that are also operating in this area kind of above and beyond the practicalities of how is Congress going to function, or even the substantive issues that are involved with any particular statute.
Perhaps a related issue, I'm not sure how to characterize it, but I'll call it political noise. Action perhaps by certain members of Congress doing the briefs to the court or sending letters to the court, or a lot of debate obviously in the political sector regarding the number of justices on the court, et cetera, et cetera. What is your sense about the regularity perhaps of this and perhaps what is the impact, if any, on the court and how the court sees its role and job and how the justices might act and react to that?
I think it's always been the case that members of Congress will get together and write an amicus brief saying a variety of things. I was there when this law was enacted, and here's what we meant, or other things along those lines. And that has been true for as long as I've been practicing before the court. I don't think there's a huge change in that regard. There was, I guess, a lot of discussion over briefs and letters submitted to the court in the context of the Second Amendment case, the New York gun case, that seemed to take a somewhat strong tone with the court, for lack of a better term, and maybe reflect some of the polarization that's going on in our political system. And so we're a little bit unusual for that reason. But again, I think, the court has always gotten those kinds of submissions, and I think sort of takes them in stride. And many members of the court these days don't feel like the views of any particular legislator are especially important, including statements made on the House floor. And so for that reason, they sort of, take those briefs for what they're worth, but aren't necessarily especially swayed by them in many cases.
It might have an impact on how the court sees legislative intent, in a negative way, perhaps, or how do you assess what legislative intent could be, might be, would be, should be, in the kind of environment we are in at this point in time?
Well, this isn't a court that cares much about legislative
No, that's
intent.
right.
They're mostly
That's right.
focused on text. We could have a long discussion about whether that's a sensible dichotomy or whether sort of not looking at all at least there were the decision not to focus on legislative intent was driven, I think, by the correct view that a lot of very specific legislative history is driven by the lobbying process and people not being able to get
We'll
statutes.
insert this into the record, and that'll
written the way they
demonstrate our
want.
position.
That clearly isn't something that courts should rely on. On the other hand, from the legislative history as a whole, getting an idea of the problem that Congress is trying to solve and what it had in mind, and using that as a guide to interpreting text, to my mind, is a pretty important way to go, because, having been involved in drafting some statutes, it's actually a lot harder than it looks, because you've got a couple of problems in front of you, and often the context in which the provision is going to be applied that creates the problem is not one that people anticipated. And so relying just on textualism, I think, may end up with answers that, since textualism is at best an inexact science, that get driven more, maybe unconsciously, by people's views about what's good and what's bad, as opposed to at least taking into account the views in this general way of the people who actually enacted the thing.
I was going to say, just a couple additional thoughts, if you might. Perhaps Sarah, on SELA, from the consequences of this, how do you see this case impacting other areas of the law? And then maybe related, Elaine, on the on the issue on lieu, are there consequences for non-statutory remedy issues in criminal sentencing, in other areas of enforcement, in other areas of regulation that might be implicated by the lieu decision?
So in SELA, I guess I'll start. Look, I mean, I worked in the executive branch at the Office of Legal Counsel, so to me, like, there is nothing more important than separation of powers type issues, because I do kind of see them as fundamental to the way our democratic process works. And so I think this is a case where, you know, assuming the court does what the conventional wisdom is and says that the CFPB for-cause removal restrictions are unconstitutional in some fashion, but, you know, probably does something very modest on the remedy, I think it'll affect really the consequences are really for the political process going forward, right? I mean, going forward, if you want a single at least at a minimum, a single member agency that is like this, Congress will need to accept that if they want to do that, the president is going to be able to remove that person at will. And whether or not these sort of broader independent agencies also have their for-cause removal protected or not is an important question. It really is sort of how are we going to be governed? What kind of oversight is going to happen within the executive branch? And so, to me, I mean, it's abstract, but there's probably nothing more important.
With respect to the implications of lieu, so I see that case as being very much, and the other cases about other agencies, as being very much about the powers of agencies and less about kind of abstract questions of disgorgement, restitution, and so on and so forth. I really do think that's what is driving the court, what drove the court in Kokesh, and what is driving the court at least to take the lieu case, because we'll see what they do, is this sense that, you know, here is this agency that's just out there taking all this money, just so much money, and no one has authorized them to do it, and because they haven't been authorized to do it, there aren't a lot of parameters around how they do it. And so in some cases, it is done in ways that I think it was pretty clear in Kokesh, at least, the court thought were sort of abusive, where actually there's disgorgement taken that leaves someone worse off than they were before they engaged in the bad behavior, not in the place they would have been in had they never engaged in it. So I do see it as a pretty agency-focused thing, and to the extent that the outcome of the cases is to decide that disgorgement and maybe even restitution is penal in some way, then presumably that's not, at least I have not heard anyone argue this, it's not going to affect the use of restitution remedies, for instance, in criminal cases, because everyone agrees that there should be punishments there.
Just
Elaine,
one additional thought, because I think it ties these things together, and Elaine mentioned this earlier. This is a court that's very skeptical about the administrative agency structure. So it's skeptical on separation of powers grounds. Who's controlling these people? Are they really subject to the political process? What kind of powers are they using? That's this case. Should there be agency adjudication? That's something that I think is coming down the pike. And then, you know, you can tie it back to Chevron and some of the cases about the non-delegation doctrine and say, you know, how much power can they have that's not very specifically cabined by Congress. And so I think this is a court that's going to be looking at all those parameters at agencies, and whose inclination is to hem them in much more than they ever have been before.
Glenn?
It's a good segue to the question that I had, which is probably the most important opinion that was issued so far this term, at least from our perspective, was one that appeared in a comment by Justice Kavanaugh to a denial of cert in the case that involved non-delegation. And as everybody knows, Justice Kavanaugh was recused from the Kaiser versus Wilkie case. From your experiences as advocates and also as clerks, certainly Justice Kavanaugh was trying to send a message there. And do you see it that way? And who do you think he was speaking to in doing that?
Yeah, I think he was saying the court that he, in particular, and signaling that the court's open to non-delegation challenges. You know, I think it's going to be very interesting to see how and no doubt there are going to be lots of them, there already are in the lower courts. I think it's going to be a very interesting question how the court proceeds, because on the broadest view of what could be prohibited, you know, huge swaths of environmental regulation, virtually everything that agencies do, as Elaine says, would be impermissible. And again, on one level, lots of people don't like agencies. On another level, if all those federal laws are struck down, states are going to have lots of unpreempted power to step in and regulate in a world where the federal government may have a lot of trouble putting its replacements into place. And so it just, it's an interesting thought experiment about what the world would be like in a world where the non-delegation doctrine is blown up to its most expansive size.
Yeah, I sort of see it as a clarion call, which the court does in some of these other cases too, that says, bring us some cases, bring us some petitions. That also is a message I took from Gundy, with Justice Alito obviously voting to say,
Yeah.
hey, bring us some cases. This is not the right one perhaps to revisit the non-delegation doctrine, but we'd like to do it. So bring us some cases and give us a sense of what the menu will look like for at least tackling the problem and getting a sense of the scope. What are the different statutes out there that we could start sort of tackling? Because, I think if you think of it in the abstract, like non-delegation doctrine equals agencies can't do a ton of stuff, then it seems sort of, formidable in terms of perhaps getting to 5 if you want to take back the non-delegation doctrine and give it some meaning. But if you get some good test cases that really tee up like extraordinarily broad delegations of statutory authority, and there are plenty of federal statutes out there that are candidates, that makes the test more manageable. So I think that's a helpful thing that the court does from time to time, and it's consistent with that.
Thank you all very much. Andy, thank you. Elaine, thank you. Sarah, thank you. And thank you all for joining us today for the Washington Legal Foundation Supreme Court midterm. We appreciate your joining us, and with that, our program is concluded. Thank you.